01862. Council appearances, please.
Ashka Boot on behalf of the city, Your Honor.
Jack Rucker on behalf of Ms. Tyson, who is approaching the council table.
Okay, this is the continuation of a jury trial that we just need to move forward with deliberations. I just needed to know if we address anything before I call the jury in and swear the court officer in for them to have their time for deliberation.
I have one matter I'd like to raise in the court.
Yes.
I was reviewing and kind of going over the testimony yesterday, and I would like to make a motion for a direct verdict on count one. Looking over the testimony of the different officers, no officer testified as they measured the length of the blade, and there is an insufficiency of the evidence gap for the elements to meet the city ordinance regarding the length of the blade. Sergeant Mueller at best testified that he estimated it to be over 6 inches. My client said that when she was on the stand, that she didn't think it was over 3 inches, and the officer who actually bagged it into evidence was Officer Shading, and he offered no testimony as to measuring the length of the blade before the close of Bruce. And so, pursuant, Your Honor, to People versus Wolf and People versus Hampton, those are kind of the two guiding case law on city evidence. And then there's also the case of People versus Parker, which established the state analog for the dangerous knife statute. Held that Court of Appeals held that is a mandatory element of the length of the blade has to be established by evidence at trial.
Your Honor, in response, I would say first, I believe this motion may be late and should have been taken up at a different time before the defense put on their case and closing arguments were given and the jury was given instructions. That aside, I believe Officer Mueller did give enough testimony. There is not a element of this charge that Mr. Mueller has to bring out a ruler and measure the knife. He can have the ability as a person who has been a police officer for, I can't remember how long he's been on the force for quite a time. He's dealt with these charges before. Also, just as a general person who can use their general knowledge, can look at something and tell if it's over 3 inches or not.
So I can't look at something and tell if it's over 3 inches by looking at it. It could be 1 inch less. It could be a 1/4 inch less. It could be 1/8 of an inch less, and it would make the facts insufficient. An officer doesn't have a training in estimating the inch of a knife. What training is that?
He does not have training to tell the exact measurement of a knife, but
he estimated to be over 3 inches, but he couldn't give us the exact length of the knife, and the elements are clear. Has to be a blade over 3 inches.
But there's been evidence presented to the jury, including visual representation of that knife, that they can make a determination on their own whether or not they believe that knife is over 3 inches or not. They don't have, doesn't have to be evidence presented.
It's not the duty of the jury to make an estimation about how long a knife is by looking at a video.
It's not their duty, but they have the ability to analyze the evidence that's been presented to them. They make
can't pass your duty to the jury. It was the people's duty to present information to support each element during their case in chief. You called 3 witnesses. You played video, and nobody ever brought out evidence about how long that knife actually, or that blade actually was. There wasn't even any real inventory information as to what was in the bag. The people were well aware that there was a potential defense, if that's what we call it, that there were other items that were going to be in the bag. Some testimony about a missing check, but some spoons and other silverware. I think there was a question, I think it was on cross, about who would have inventoried the bag. There's no evidence that the contents of that bag was ever inventoried, that they ever took that knife and actually measured it. There was no picture of the knife. there's a video, and you want me to say that because the people, the jury saw the video, that they can estimate what, or the length of that is, and that it's over 3 inches?
No, that's not what I am saying is the evidence that was presented in front of them, including testimony of the officer who says he believes that knife was over 3 inches, in conjunction with the video where they can at least see it. They don't know what the exact length of that knife is, but they have the ability to believe, I don't think that's 3 inches.
I have the ability, she has the ability to believe she's a millionaire. I think I heard that on the video. Does that make it true?
No, but that gives the jury the ability to believe, to decide on their own if they decide the fact is true or not. They are the triers of fact.
That's not, no, you have to present evidence first. And the motion is that there's been insufficient evidence to even put it before a jury. And I agree. There has not been any information put forth by the people that would establish with any reasonable certainty that this knife was over 3 inches. There was a kitchen knife, which I saw briefly pulled out of a bag on the video. The jury saw the same thing. There was never testimony, did you measure the knife? That's normal questions for the prosecution to ask their witness if you're going to charge someone for having something above the legal limit as it relates to the inches here. Give it an example. Do you think that we can just let people get drunk driving and we estimate that their blood alcohol level is above a 0.08, or do we actually have to measure it?
But they can be arrested based on their.
But can you put it to a jury based on, I estimate that their blood alcohol level was above a 0.08, or is there a requirement that the people put forth some evidence that shows some measurement?
I think
you don't want to answer that question.
I think we're.
You answer the question first, and then I'll let you get
we don't put an estimation of a intoxication in front of a jury without any other evidence. But I believe Officer.
No, it's measured. Right. It is measured because there's a requirement that some measurement show that it's above the legal limit. So you can bring it to the jury. We can't just arbitrarily put information before the jury for them to try to sift through and make their own determination. That is the whole purpose of the motion for direct verdict. That's why there is that opportunity available to the defense, so that if the prosecution has not met their burden to bring sufficient evidence to even bring to a jury, that we don't leave it to a jury to try to sift through and make up the evidence on their own. That's not appropriate. It's prejudicial. And it was clearly the element was only that it was a knife above 3 inches. All you had to establish was that it was above 3 inches, and that was never established.
What I would like to say is, Your Honor, I believe that, and I don't have the case law in front of me. I believe only a scintilla of evidence to that element has to be presented to the jury.
Based on what case law are you?
And I don't have it in front of me.
It doesn't have to be only a scintilla of evidence. You have to prove that beyond a reasonable doubt.
That's for them to.
The element that you have to prove beyond a reasonable doubt is that the knife was above 3 inches.
But it does not have to be proved beyond a reasonable doubt just to get to the jury. That's for them to decide.
You have to put evidence before the court, before the jury, that sufficient enough for them to make that determination. You've not put anything on this record to tell if this knife was 6 inches or if it was 2.5.
I believe Officer Mueller was asked directly, do you believe how long was that knife? And his testimony was it was 5 or 6 inches.
No, he approximated it to be 5.
That's the evidence that was put forward to the jury, and it's for them to decide whether they want to believe some, all, or none of what that witness said.
No, because if it's a motion that it's insufficient, now it's my duty to respond as to whether or not that was sufficient enough to put to the jury. I do not believe that given an approximation where the element is to be exact, that it's above 3 inches. That I looked at it, nobody testified as to, or a question that witness as to whether or not he was trained to estimate length of a foot. We don't know anything about that. I don't know anything about this officer and his ability to guesstimate how long a knife is. I don't even think that guesstimating the inch is reasonable under the circumstances. If you're going to charge someone with a knife over 3 inches, then you're going to pull out something to measure it.
Your Honor, I would ask for the ability to brief this? If the court doesn't want to allow that?
I'm gonna take the motion under advisement anyways, because we've already brought, I've already given final instructions and told the jury that there were two cases that they'll be deciding for. I do agree that you dropped the ball by not making the motion when you should have been making the motion before you gave your case after the.
I agree, I agree, Your Honor, that I should have made the motion to close the prosecution's proof. I believe that under the rules, I still would have had the opportunity at the close of our proofs that I could have raised it at that point as well. But I recognize I raised it at neither point. The jury's been set out. It would almost be like a JNOV at this point, that if the verdict does come back, I would ask that be dismissed as a matter of law pursuant to this issue. But
I will allow the parties to make or to brief the issue if necessary after the jury makes their decision.
thank you, Your Honor.
Any other matters? We can call the jury in.